For a long time, case backlog has remained a major challenge that the judiciary has been faced with. The problem has persisted despite numerous efforts directed at reducing its caseload. As suspects continue to languish in prisons and more case files piling in the judicial registries, the cry for more judges continue to resound even louder, but to a deaf ear.
I have 53 judges in High Court, some of them not even serving, and yet the complement would be, a full complement would be 82. So up to the time we shall get to 82 judges of the High Court, I can assure you the shortage is what you are seeing now.
More than 1,000 cases in the criminal division of the High Court have spent 2 years without being heard out of the 5,600 cases. The judiciary is now seeking to introduce the plea and sentencing bargain system to reduce the case backlog. Under this system, the prosecution talks an accused person into pleading guilty for an offense to which overwhelming evidence has been presented in order to avoid going through a lengthy trial.
Where there is a plea and sentence bargaining, it cuts out the hearing of evidence. You go, you are charged, you accept your case, you bargain. And you bargain and accept your case, and it is ended there. You go into sentence. So the trial aspect does not come in. The hearing aspect does not come in. So that way it makes trial quicker. And it reduces the number of cases which would be pending for trial, thereby reducing the backlog.
Once the accused person pleads guilty, the negotiations with the prosecution begin on the sentencing, which is presented before the judge. This system, according to the Director of Public Prosecution, Mike Chibita, provides the accused an opportunity to negotiate his sentence.
So now with the guidelines in place, we know the minimum, we know the maximum. So you commit an offense, we have evidence, we say instead of going to full trial, if you plead guilty, we'll ask for the minimum rather than the maximum. And then we can negotiate. That should help us clear backlog.
But the final discretion for passing the sentence remains with the judges.
At times, even the victim can forgive. But then, the victim is not the one who is accusing. The state is the one which is accusing. The victim can forgive, but you might say there is some element which you must have some little punishment. So then you might find him going for community service as a punishment. But the victim is aware that he is certified this person was tried and convicted.
Previously, the sentencing was based on judges' discretion, but now such decisions will be based on sentencing guidelines. This will help provide uniformity and consistency in sentencing rather than leaving the entire decision to the judges.
The judge gives his sentence. He is going to be required to give very good reasons why he has arrived at such a sentence. So these guidelines are now making sentencing more transparent, more certain, more predictable. Magistrates and judges can no longer play around with sentencing.
The guidelines also mandate the judges to justify the decisions that led them to pass their sentence and requires them to review them in line with the time that the accused person has spent on remand.
If he has spent on remand 2 years, then the judge will say, okay, I would have given you 7 years. But since you've spent on remand 2 years, the sentence is now reduced to 5 years.
Solomon Serwanjja, NTV Weekend Edition.